Hello guys, welcome to this video. Today we are going to examine the law of treaties. A treaty is also known as an agreement or an international convention. So a treaty is an agreement that establishes mutual obligation under international law. We also have to note that treaties create consequences, they create rights and responsibilities, and also they have to be made, and also they declare the consent of the parties involved. Treaties are made by subjects of international law. We have to note that subjects of international law possess rights and responsibilities. Treaties are governed by the Vienna Convention on the Law of Treaties of 1969. It spells out the terms and conditions that states must adhere to in the making of treaties. So we have two types of treaties. One is lawmaking treaties, and in these treaties a large number of states participate, and binding procedures that are made upon all of them. Another type of treaty is called treaty contracts, and these usually involve one or two countries and very few states. So in the making of treaties, we have some steps which are followed, starting with the text. The text is proposed and formulated. After that, we go to the process of formalization, whereby it is formalized by voting or by the use of deadline. After the formalization, we have the authentication, whereby it is authenticated by signature or by initials. So after authentication, the treaty gains what we call a bindingness, after which it is signed. Upon signature, the state parliaments may have to ratify the treaty, and this takes place in constitutional frameworks such as parliaments, whereby the state approves or rejects the treaty. Upon ratification, the treaty becomes part of now the law, or it is incorporated into state practice. So in a case whereby a state includes another state that is not in a treaty arrangement, this process is called accession, whereby other members are allowed to enter into the treaty. So after all this, the state has to register the treaty under Article 1 or 2 of the UN Charter to avoid what is called secret diplomacy. State must register treaties with the Secretariat of the United Nations. So the United Nations Secretariat registers it and adds it to its own archive. So there are some conditions which make treaties non-valid or impinge on the validities of treaty. These include, for example, if a treaty is not signed, it is not valid, or if it is signed by an authorized person, it is also not valid. Even when a treaty is signed upon coercion or use of force, or even when the use of things such as corruption, or also mistakes or errors in the treaties, and just cogence violation, all these render a treaty invalid. So after that, let's examine the concept of treaty interpretation. So treaty interpretation is whereby now we try to decipher the meaning in the words of the treaties. So the interpretation should be done in good faith by legal specialists or politicians or any other actor that has the capacity to do it. We examine the concept of reservation, and reservation is when a state signs a treaty and leave some sentence or some few elements of the treaty. So a state can make a reservation whereby a certain clause of a treaty is changed to favor it. we examine the concept of termination, denunciation, or withdrawal from a treaty. So, according to the Vienna Convention, if a state wants to withdraw from a treaty, it must submit a 3 months notice in advance. A state can withdraw according to the withdrawal clauses. Thank you for watching this video. Like, share, and subscribe.